Hello, I'm Cliff Stevenson and I'm the Helpful Economist. Today we're looking at the question, does EU law apply in Northern Ireland? We'll also take a quick look at whether the UK can veto an EU law and the role of the European Court of Justice. So, does EU law apply in Northern Ireland? The answer is an unambiguous yes, but we need to see this in context. The Northern Ireland Protocol states that Annex 2 of the protocol lists all the EU laws that apply in Northern Ireland. Here's the first page of Annex 2. The list of laws is long, and in total there are about 300 laws listed here. This might seem like a lot, but let's put it into context. The EU's Directory of Legal Acts suggests that there are 27,258 laws in effect. So 300 out of 27,000 is around 1%. The UK government has said that it's 3%. Whatever the precise figure, it's a relatively small proportion of EU laws that apply in Northern Ireland. Massive areas of law do not apply. For example, laws relating to free movement of services, labour and capital. The protocol requires that any amendments to the 300 laws and any new EU laws on goods apply in Northern Ireland. The exception to this is when the UK government applies the Stormont break. So, as new laws relating to free movement of goods are adopted by the EU, two conditions must be met for the UK to apply the break. The first is that there must be a significant difference to the previous legislation, and the second is that there must be a significant impact on everyday life in communities in Northern Ireland. These conditions are very subjective, but I do expect the EU to be quite pragmatic about this. So does the UK actually have a veto on any EU law applying in Northern Ireland? Well, the answer to this is yes and no. Yes, the government could outright refuse to adopt an applicable EU law. If this was the case, the dispute settlement provisions of the withdrawal agreement would be triggered. This would involve a process of consultation and arbitration. It would hold up the application of the law, and if there wasn't agreement between the parties, the dispute process will produce a binding ruling that the two parties must follow. Now, if the UK is obliged to adopt a law as a result of this, and it does not, nothing can force the UK to do so. However, the EU would be permitted to take remedial measures, and ultimately this could start a trade war between the EU and UK. So yes, there is a veto, as there is with any part of the agreements that the EU and UK have. But the cost of not adopting a particular law may be high in terms of losing other benefits and concessions. Does the European Court of Justice have any role here? So the answer to this question is yes, though the role is somewhat limited. I already mentioned the dispute settlement process, where there is a dispute on any aspect of the UK's implementation of the agreements covering Brexit and Northern Ireland. In such a case, there would be initial consultations. If no agreement, then an arbitration panel would be set up, and if the panel rules that the UK should comply, and it does not, then non-compliance measures would be authorised, and there would be the possibility of a trade war. Now, the European Court of Justice has no direct role in any of this, but if part of the dispute is how EU law should be interpreted, the court does have jurisdiction over this. Any ruling of the court on interpretation of EU law is binding on the arbitration panel. In conclusion, some EU law does apply in Northern Ireland, but only that necessary for Northern Ireland to remain in the single market. This is a compromise in terms of sovereignty, but it's perhaps worth it in relation to the economic gains. I hope you found this information useful. My name's Cliff Stevenson. I'm the Helpful Economist. See you next time.